The UK's restructuring toolkit. The UK has an internationally renowned and respected toolkit for restructuring financially distressed enterprises. One of the most widely used and effective tools in the toolbox is the pre-pack. Approximately 1/4 of all company administrations involve a pre-pack. Recent examples include Interserve, House of Fraser, and Evans Cycles. In this short video, we explain what a pre-pack is and how it can be used to rescue a viable business from an insolvent owner. Interestingly, in the UK, pre-packs were not designed by lawmakers. They are a technique developed by insolvency practitioners to help preserve goodwill and going concern enterprise value in distressed businesses. So, what are pre-packs and why are they useful? In simple terms, a pre-pack is a sale of some or all of a distressed company's business and assets to a new owner the moment after the company enters into a formal insolvency process, but on terms negotiated and agreed before the insolvency process is triggered. Structuring the sale in this way enhances the prospects of preserving goodwill in the business and going concern enterprise value for the benefit of the seller's creditors. This is achieved by completing the sale before suppliers, customers and employees find out about the formal insolvency process and start to walk away from the business. The insolvency process may be an administration or a receivership. The buyer may be a third party or someone already connected to the business, such as the existing owners or management. Who negotiates the sale terms? The terms of the sale are negotiated by the prospective insolvency office holder and the prospective buyer. Typically, the prospective insolvency office holder is bought in by the directors or a secured creditor. The insolvency office holder will sign the sale agreement as soon as he or she is appointed to their office as administrator or receiver. How is the sale price determined? The sale terms are a matter of negotiation between the seller, acting by the prospective insolvency office holder, and the buyer. To properly discharge their duties, the insolvency office holder will seek to achieve the best outcome for the selling company's creditors. Usually, this is achieved by ensuring that the price paid reflects the fair market value of the assets being sold. Ideally, the market value, or price, is determined by there being a prior marketing exercise, even if only an accelerated basis. Sometimes the level and pace of distress in the seller's company is such that there is no time for marketing. In this scenario, the price is usually determined by reference to independent professional valuations. If the assets being sold have been charged in favour of a secured creditor, the secured creditor will be consulted and lined up to release their security when the assets are sold, in return for their entitlement from the sale proceeds. Is court sanction required? No. The court may be involved in commencing the formal insolvency process and dealing with any disputes arising from the pre-pack, but an insolvency office holder is able to effect a pre-pack without court sanction. Do pre-packs benefit creditors of the insolvent company? Yes. In a good pre-pack, creditors benefit from greater asset realisations in the insolvent company, when the assets are sold with an enterprise value rather than on a breakup basis, less claims against the insolvent estate because employees transfer to the buyer and the buyer continues to perform contracts that might otherwise be terminated, leading to breach of contract claims. Reduced costs in the insolvency process because the insolvency office holder does not have the expense of running or closing the business, and there being a continuing business to deal with in the future. With all these benefits, why are pre-packs still controversial? Not everyone agrees that the pre-packs are good. Critics of pre-packs major on the lack of transparency that is inherent in the process. Typically, unsecured creditors are kept in the dark until the pre-pack has happened, whereas secured creditors find out beforehand if a release of their security is integral to the sale. Some consider this differing treatment to be unfair to unsecured creditors, even though the pre-pack may produce a better outcome for them. Levels of accountability. Because pre-packs have been developed by practitioners rather than lawmakers, there are no purpose-made avenues to challenge them. But this doesn't mean that pre-packs cannot, in fact, be challenged. In the UK, by regulation, after a pre-pack has been executed, an administrator is required to provide creditors with the information they need to be able to conclude that the pre-pack was appropriate and carried out in creditors' interests. This is known as CIP 16 report. If the administrator has not properly discharged his or her duties, for example by selling at an undervalue, he or she can be sued for loss caused, and regulatory action can be taken against them. And finally, there is the Phoenix syndrome. A pre-pack can involve a sale to a connected party, for example, existing shareholders or management. There is scope for the process to be abused by unscrupulous connected parties to avoid paying debts while holding on to their business. This fuels the image of the same directors driving the same Rolls-Royce through the same factory gate. Given these different schools of thought, should pre-packs be banned or promoted? In the last major review of pre-packs conducted in the UK, pre-packs were endorsed, but with recommendations on how they could be improved. A report prepared by Theresa Graham OBE and published in 2014 concluded that pre-packs benefit UK PLC and definitely have a place in the insolvency arena, and outlawing pre-packs to address suboptimal behaviours would be throwing the baby out with the bathwater. Instead of suggesting that pre-packs be outlawed, Graham made a number of recommendations to improve pre-packs, particularly those involving connected parties. Graham's recommendations included the creation of a pre-pack pool, a pool of experienced business people that connected party buyers can ask to opine on a pre-pack before it is executed, on a voluntary basis. The introduction of viability reports, an option for connected party buyers to prepare a report on how the business is expected to survive for at least the next 12 months. Better marketing. All marketing should comply with 6 specified principles of good marketing. Better valuations. Valuations should be conducted by valuers with professional indemnity insurance. And a revised CIP 16, bolstered to require more narrative about the background to the pre-pack, the reasons for it, and the steps taken to market and value the assets sold. Following Graham's report, the bodies that regulate insolvency practitioners took steps to implement all of her recommendations on a voluntary basis. That is, without the need for changes in law. In 2015, new laws were introduced to give the Secretary of State power to make regulations governing connected party pre-packs. This power may be exercised if self-regulation proves to be insufficient. To round up, it appears therefore that the UK pre-pack is working and is here to stay, despite some of the criticisms.